What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. It's been a couple weeks now. The Florida Law Weekly has actually been a little quiet on family law cases recently, but we do have 3 for you this week, and they're from a couple weeks ago. First one is Frank versus Frank. This is out of the 4th DCA, and this has to do with the tax dependency exemption. In a lot of our cases, we say which party, mom, dad, husband, wife, who's going to get the ability to claim the child as a dependent on their tax returns. And so we include this in our parenting plans, our MSAs, all the time. And so what happens if the court just doesn't say which party is going to claim the tax dependency exemption? Well, the default rules under the IRS say that the custodial parent, which is basically in Florida the parent with the majority time sharing, by default gets to claim the child as a dependent. And so in this case of Frank, the trial court did not decide who's getting the dependency exemption. And so the father, the husband, was saying, "Hey, you guys, your court, you didn't even say who gets it." And so he appealed in part, and the appellate court said, well, the trial court really doesn't have to say who gets the dependency exemption. By default, the parent with the majority time sharing, which in this case was the mom, she gets it. And so there was case law that mentioned that the court erred by not saying which party gets the dependency exemption. And the court here said, well, that was a different case because in that case, the parties had equal time sharing. So the court really had to decide who's going to claim the child as a dependent because there is no custodial parent, there is no majority time sharing. But in this case, or in cases where one parent does get majority time sharing, the trial court does not have to say who gets the dependency exemption because it automatically goes to the parent who has the majority time sharing. Next case is Shlimbaum versus Shlimbaum, and that's out of the 4th DCA. And this was an interesting one about the merger doctrine. This had a convoluted history, but basically the parties had several temporary support orders, and the payor spouse, which I believe is a husband, failed to pay the temporary support multiple times, and so the wife got multiple contempt judgments and orders against him for the failure to pay the temporary support. And I guess the case was going on for so long that they agreed to a partial final judgment divorcing the parties. Sometimes this happens. And so a couple of years after that, the husband must have gotten a creative lawyer, and essentially the husband's new lawyer argued, well, wait a minute, because of that partial final judgment, those temporary support orders actually merged into that partial final judgment, and because the partial final judgment did not explicitly refer to or incorporate and preserve those temporary support orders, they no longer exist. Boom, poof, vanished. Bye-bye. No longer need to pay temporary support. Can't be held in contempt. Those orders are essentially void, is what the husband was saying. And the trial court actually agreed. It said, well, listen, merger doctrine, there wasn't any explicit reservation of jurisdiction to enforce those temporary support orders. So by pursuant to the merger doctrine, they have now merged into that partial final judgment, which only dissolved the parties' marriage. It did nothing else. And so the trial court said, the appellate court said, no, wait a minute. The parties' parenting plan referenced the temporary support orders, and the parenting plan was incorporated into the partial final judgment. And the other key is basically that the partial final judgment was not an actual final judgment on child support, alimony, or anything like that. So because it wasn't an actual final judgment that completely got rid of those claims, those causes of action, the merger doctrine really did not apply. The merger doctrine would apply only if it was a final order, final judgment on those issues. And because this was a final judgment only on the dissolution of the marriage and incorporation of the parenting plan, the merger doctrine did not apply in that situation. But something to keep in mind, because I know sometimes we include language in our final judgment saying certain things are not merged, and you don't always think about, wait, why is that merger doctrine so important? It could be important because if it is an actual final judgment, all those previous orders and even the MSA, the contract itself, are merged into that final judgment so that you can only enforce the final judgment and you can't enforce anything else that's outside of the final judgment. Sort of like the merger doctrine for contracts. So something to keep in mind for sure. Last case is Garnett versus Duvalsaint. This is out of the 3rd DCA, and this is basically a reminder, if you're going to appeal, you have to have a transcript. You have to have a solid record of the trial court below. Happens all the time. I argue this in certain appeals, saying, hey, listen, they didn't get a transcript, so therefore, you lose on appeal. And that's basically what happened here. It said, in absence of the transcript of the underlying proceedings, which is basically, it was a general magistrate proceedings, and they only got partial transcripts of the general magistrate proceedings, and then they didn't even get any transcript of the motion to vacate the recommended order of the general magistrate. So, too bad, too sad. You didn't get a transcript. You don't have a solid appellate record, and so the appellate court said, sorry, I can't reverse on that one. Basically, forced to affirm. All right, guys. Well, I missed you. I hope you missed me too. I'll see you guys next time. Take care. Hope everybody has a great week.